Hi, everybody. I'm Lisa Ascolese, the Inventress. I'm the CEO and founder of Inventing A to Z, where I help you inventors take your products from a napkin idea all the way to the marketplace and everything in between. And here we are at the Inventresses podcast. So excited to share this time with you with my friend Eli. Eli, come on. How
Hi,
are you?
hi, Lisa. I'm excited to be here. Thanks for having me on.
So excited to have you on my podcast. I was on yours. And let's get the party started. So, Eli, first of all, I love the name of your business. Love it. I love that you have your, well, I think patents or your law degree behind you, right?
Yeah, it's from when I became a patent agent and then a patent attorney. So those are the
Love
USPTO certificates. Yeah.
Congratulations. So, I want you to introduce yourself. Tell me about what you do. Tell us about what you do. And obviously, your business name. This is your business, right? That's
Well,
the
yeah,
name
that's
of it.
right. Yeah, yeah. So I'm the reason we met is because I have the Clause 8 podcast, and Clause 8 is named after the uh, portion of the Constitution that intellectual property rights are based on. So it's Article 1, Section 1, Article 1, which is I guess, the part of the Constitution that deals with the executive branch, Section 8 and Clause 8. So this is the IP clause of the Constitution. So when I started my podcast, I named it after that. So it's called Clause 8. And I started it just because I loved having long conversations with people like me and you did. And I kind of wanted to share them with everybody else who's interested about patents and intellectual property and learning more about how the system works and about how it could work better and so forth. So that's kind of my. I've had a lot of fun with it over last year, and I have a website www.voiceofip.com where we kind of share the podcast and share some other news that people might find interesting about the patent system. But by day, this is kind of my hobby, but my passion. But by day, I am a patent attorney. So, like the certificates that I discussed behind me. So, I work for a law firm called Foley and Larner, and we do everything. We kind of any legal issue that somebody has or might have or think they might have. Uh, Largely with
In the future,
yeah,
in the
yeah.
event you have an issue.
Yeah, we help with that. So that's what I do. That's what I do day to day. But this is a lot of fun, as
We
you
help
know.
with future lawsuits
Yeah,
or future patents.
yeah.
You are in the best position. What I love about having you on my podcast is I can ask you questions about you. You ask me questions about myself. So I never really got to ask you about what you did. I know that you're a patent attorney, intellectual properties, which I love. I'm finding this out for the first time. Why you named your podcast Clause 8. That's amazing to me. If I was a patent attorney, all I would do is patent products all day for myself. I mean, I almost do it now.
Yeah.
I have patents all day long. I think of products, that we talked about that.
Yeah.
But my
But I,
gosh,
I say the opposite. If I was thinking of products all day long, I wouldn't have become a patent attorney. So
exactly. Exactly. But
yeah.
this is what I do. That's why I don't do things for myself because I'm not that. So what I do is I help my clients develop products, get them patented, um, getting them on the market. And this is where you come in. And I love your passion. I love how much you love what you do. This is the best thing ever. You love so much what you do that you named your podcast after. Let's do you said what is it? Section 8,
Yeah. Article 1, Section 8, Clause
Article
8.
1, section.
Yeah.
I think the best thing I've ever heard on my show in terms of that, because I'm always like, I love inventing, obviously, love patenting, trademarking, and working with very intelligent people like yourself. And then your day-to-day business is what? What's the name of it?
Foley and Larner.
For okay.
Yeah.
So I have to ask you this. What made you go into patent law?
Sure. Great question. So I guess I was studying computer science in my undergrad because I kind of wanted to learn. I thought I want to learn something practical that I could kind of find a way to apply. I come actually from a family of engineers. both my parents were computer programmers, but to, uh, by the time I went to college, I kind of knew I wasn't cut out to be a computer programmer because, that takes a lot of focus and fixing bugs and kind of a special way of thinking. And I just didn't think I'd have the patience for that. And actually, through a friend of mine who at the time we went to college together, his name is Chris Agarwal, and I've had him on my podcast. He organized this event for IP attorneys to come to talk to us for patent attorneys. And they told us about the field where your job is to help inventors and innovators figure out a way to kind of protect what they have and kind of protect the future, what they're thinking about, and help them build a business around that. So I thought that was really cool, and I thought it'd be a great way to kind of, um, you know, uh, use my engineering background, but also with my other interests that I had, and I had some legal interests. I used to watch kind of, all those People's Court, Judge Judy, Court TV. So
I wasn't going to say it. So I was not going to say it because I didn't want to insult you. I didn't know what was an insult. What, did you watch Judge Judy? Is that what made you become a patent attorney?
I
No, but
did,
I mean,
yeah,
thank you. Thank you, Judge Judy.
yeah.
But I have to tell you, you're the most unique patent attorney I've ever met. And I've met many. I'm in this business for so many years, over 35 years. And I've never met a patent attorney like you. Like, you make me smile. When I got on your show, you made me smile. Like, you just have such a wonderful energy and excitement. And I thought you were so much younger than you are. I mean, we're not going to talk about your age today, but you are. You're so exuberant and so excited about what you do. I love it. I love it. And therefore exciting inventors. Like, you are the guy who will excite inventors about moving forward with their patents or trademarks or anything else to protect their properties. And does that include business properties?
Does
So
what?
not just an invention, but does that include intellectual properties when you're talking about intellectual property so that the listener understands? Is it just patents or is it for businesses as well?
No, it's a great question. So yeah, so I think when people, when some people find out about patents and they say, "Well, I have
Uh-huh.
an invention, I could just get a patent, and then I'll
Right.
just somehow make a lot of money." There's
Sure.
just by getting a patent, but that's not how it works. A patent is really just a tool to be able to build a successful business. And to build a
Mm-hmm.
successful business, at the end of the day, you need somebody, um, people who will want to use your innovation. So it's just one of the tools. It's not always the appropriate tool. If your patent is going to cost more, if getting the
Mm-hmm.
patent is going to cost you more than any amount of money that you'd make off selling the product, it probably doesn't make sense to get a patent. So it's one of the tools. I think, as you and I discussed, there's other tools, there's trademarks. Sometimes if what you're doing, what your real innovation is a secret,
Mm-hmm.
um, you just want to keep it as a secret, right?
Right.
One of the famous, the Coca-Cola
Yes.
recipe, and
So a trade secret. So,
yeah,
so a trade secret, does that also include, so all right, so we're talking about Coca-Cola and we're talking about trade secrets and intellectual properties. So let's do trade since we're there. So if somebody develops a food, right? A food, Kentucky Fried Chicken. So and they have a secret recipe. Can you protect that product, that food?
well, yeah, I guess you could protect. Trade secrets cover a lot, including, I
Mm-hmm.
guess, how your company operates and would make, um, whatever the product it is, including food. But the question comes up is, you can't. It's not a trade secret by just saying it's a trade secret. There's all these requirements to follow, and one of the requirements is, for example, that you really have to kind of take the effort to keep it secret. If you're like posting it on the internet, it's not a secret. If it's, for example, if it's something that could be easily reverse engineered, again, there's no value to a trade
Ah,
secret because somebody can easily do that. So, for example, if you have a mechanical product, like I have, it's called the Bionic Wrench here.
okay.
Somebody could take that apart and see how it's made. So trade secret wouldn't uh, protect it. Um, but if it is something that you'll be able to keep secret, then it is. A lot of times these days it comes up, if it's like, for example, internal business operations, or you have some kind of software product, but um, you're running, the way it works is going to be held secret, then obviously those kind of things you might want to consider to kind of not filing a patent application. So ideally, and I think me and you discussed it, you really have what it's called like a broad IP strategy,
Mm-hmm.
where you kind of figure out, hey, this is my business goal, and I think you talked about that. And these are kind of, this will help me make sure, maybe build a moat around what I'm doing.
Right.
So, and I, I think I've heard you talk about it, but it's really the brand name. That's very important. Obviously, if you build
For
a
sure.
business, people love it. Um, you want to have the strong brand name that if somebody tries to rip you off, they're going to kind of, yeah, trademarks are relatively easy to enforce, much easier to enforce than patents. So it's something that I guess you want to be thinking about,
I
having
love
those
that.
broad set of
I
rights.
love that. I love that you're saying this because there's so much confusion. I mean, there's so many different types of patents, and I could have you on for 3 hours talking about this. So many different types of patents. So we're talking about intellectual properties. We're talking about uh, uh, secret ingredients to a food. And I just want to go back 1 second and talk about food because I'm a big foodie. So creating, let's just say for not argument's sake, but just to give the listener some idea. So you just said if you reverse engineer that thing. So if I made curry and vinegar and I made this something like whatever, I was making a meatball or a soup, and I used vinegar and curry, and I didn't divulge that those ingredients, right?
Yeah.
But it's what made the thing taste so delicious. But I also use salt, pepper, garlic, and all of those other
Yeah.
things. So do I need to divulge to you or any patent attorney what I'm actually creating in that food in order for it to be protected?
No, I mean, for trade secret, you don't need to divulge it, but I guess, if you want, if you are going to talk to an attorney can kind of help you figure out the parameters about what steps you need to take for it to be considered a trade secret. So that's kind of the help there. And a good point, I guess you mentioned about the different types of patents.
Mhm.
Um, there's two types of patents, and those come to mind. And I kind of remiss not to mention that one is utility patents, and that's what
Mhm.
most people think of. And those are kind of cover the function. So if you come up with a new invention, they cover that. But there's another type of patent which is, I think, kind of underutilized, and that's a design patent. And the design
Yes.
patent covers the ornamental appearance of something. So, um, and it's famously, if any of your listeners remember, maybe when you know, Apple came out, and and then Samsung came out with a similar phone, and they were suing each other.
Right.
Apple was actually able to build, to actually win in that litigation, because of their design pattern covering the way their iPhone looked, the user interface of that iPhone looked. So it wasn't really the anything kind of behind the scenes that kind of victory. It was really about the look, the appearance. So and again, that goes back to kind of what you're saying is like, you build a company around a product, and you have a recognizable product. Trademarks go into that, trade secrets, but also there's design patents, and that's another option. And sometimes you want to be careful, but that is sometimes much easier option. So depending on your invention and what you're dealing with, it might be something to consider.
Yeah, I like that. I like discussing that because it is the truth. I mean, I always look at that trademark piece too because it's an easier thing um to protect, right? If you come up with something that's like what you did, so incredibly unique, the look and what you're using it for, that trademark. I mean, I'll never forget yours now. Never, ever, ever, especially understanding what it's all about. But I think a trademark is very important because the shopper is not saying, wow, I wonder if this is patented. I'm only going to buy this if it's patented. But the consumer will look at it and say, I saw that. I saw that. I saw that on social media. I saw that on wherever I saw it. So your trademark, right? Your trademark is your success as far as I'm concerned, especially if you keep on promoting it and branding it. Which brings me to a question, right? So, when can you get that trademark?
Great question. So that's a bit outside of my wheelhouse, but the main thing is that you have an intention or you're using it for commerce. So as soon as that is the case, then it's a good time to get a trademark. And there's obviously, there's the way I guess on a high level it works is like you have a trademark, which is like the name, the logo, whatever the name, and it's used for a particular type of business or particular type of field and a particular geographical area. So theoretically, even if you don't register a trademark, let's say you have a very successful um, business and everybody associates with it that name, you still have a trademark rights, but registering a trademark makes those things easier and kind of assures it. And I think as you rightly pointed out, it is it's usually much easier to figure that out. But if you think that's going to be an important part of your business, that's something you want to think about it before you invest heavily on a brand name, right? Um, Sometimes even for depending on the business, I've had somebody on my podcast. He's an Israeli trademark attorney, so a lot of times he helps American companies or foreign companies when they come into Israel. But when they come into Israel, they find out, well, there's a business already with that name. Similarly, he
Ah,
helps Israeli businesses go into Israeli clients that he has, then go into
uh-huh.
America, and then they might encounter, well, somebody in America already has that name. So it's something that you want to, I guess, something worth at least considering. And obviously, you don't want to you don't want to spend too much time thinking about the legal stuff and not thinking about the actually how to make the money. It's one thing at a time, and
Right.
there are ways to resolve that. But I guess it's something to kind of just to be aware of. Uh, aware of.
I like that. I like what you brought up because now we're talking about international, right? So the Israeli attorney is working with people over there, but then when they come here, so now it's something that they need to consider. What do you do? So what do you do if it's already being used here, which is probably very unusual, right? A whole trademark, a whole look, a whole
Well, yeah, but it could be a name for a company. I don't know, like whatever it is. But it's like sometimes things kind of if you're in the field, that it makes sense.
no,
What
right.
security? Yeah,
Exactly.
yeah,
So which brings me, let's go back to intellectual properties and
yeah.
patents, right? So same goes patents, right? So if you patent something here in the United States, do you have to patent it in other places around the world?
Yeah, so you don't have to, and I wouldn't recommend doing it. It's very expensive to do it all around the world, but it is important to know, and I think that's what you're kind of getting at, is that a
Hmm.
U.S. patent only gives you right to exclude others from practicing that invention. Oh, it's a theoretical, I guess, but it gives you those patent rights only in the U.S. So, and so sometimes that's not enough, especially for example, let's say um, you know your your product is uh, being made somewhere else, or components for that product are being made somewhere else. Like if, for example, like somebody makes a machine in another country and then they ship them to the U.S. to make your product. Um, you know, and then the U.S. is very hard to enforce. So I guess, anyways, long story short, my point is that you, the it, the U.S. patent protects U.S. patent. If you want protection in, let's say, in China, then you need to get a Chinese patent. In Europe, you need a European patent. And that's actually nice. There is a concept of a European patent, which kind of gives you coverage in a lot of different countries. But for Canada, you need a Canadian patent and so forth. And so that's something else to consider because it does get super expensive. So
Hmm.
you get one patent in the, you file for one application in the US, and then you decide to, hey, let me file that all around the world. super expensive unless
Right.
you're like in the pharmaceutical space or in some technology that 100% will be used everywhere. It doesn't make sense to do that. You kind of want to think about strategically about, hey, all right, let me maybe file it. Um, just example, in the US and then maybe in Europe, because I feel like this will be very popular in Europe for XYZ reason. Or maybe this will be very popular in Brazil because in Brazil people are really into it. Um,
Right.
and
But
so
but that's the hardest thing to know. So this is the toughest question for me in my business. My clients will say, "Okay, I'm gonna apply for the patent here in the United States." And now the patent attorney is saying to me, "Okay, you have only so much time to now patent it in Europe or in Canada because once you file that patent in the US, you have X amount of time to patent it wherever, and you're the expert." And the other thing is, I have to ask you, if we're manufacturing, I manufacture all over the world. If I'm manufacturing in China, do you think it's um, prudent to patent in China? Do you think it's prudent for me to patent in India? What are your thoughts on this? This is a question that comes to me every single day in my
yeah, no, no,
business.
great question. Even in the US, the process of obtaining a patent could get expensive. So one thing that I recommend, especially depending where you are in the business, it's very important to consider. I actually recommend if you're just a new entrepreneur, you just came up with an idea, you just think it's going to be successful, don't even file a full application in the US. File what's called a provisional application. A provisional application. So filing a provisional application in the US gives you a year to decide whether you want to pursue additional rights elsewhere in the US and
Hmm.
abroad. So after that year passes, that's when you can consider, hey, I think I'm going to getting some traction with this. I think it's worth kind of doing it. At that point, there's other options. One is you could file in the US, but you could also file what's called a PCT application. And a PCT application basically the purpose of it is to make it easier to file all over the world. But that's another way to buy you time. Um,
Is that in
but
addition to? Is that in addition to? So you have filed a provisional patent. It's a 1-year patent. In addition to the provisional patent, the PCT is a PCT filing an additional filing?
exactly. So you file the provisional application and you file with the
Yes.
patent office, and nobody will know about it unless you decide to. Within a year, you have to do it. Within a year, you have to file an application based on it, either a non-provisional in the U.S. and or in other countries, or a PCT application. So yeah, so those are additional filings. But a provisional application, you could do it for relatively cheaply. Um, you can kind of you can kind of do it. The other advantage is that the earlier filing date you have, the better it is. So you file a provisional application, then if you file a non-provisional, whatever, you get the benefit of that earlier the filing date of the provisional application. So there's benefits. So there's benefits to that. But yeah.
So it's the date. So for everybody out there listening, we're talking about a date. So when you're filing a provisional patent, we're talking about a date. So the first to file, right? So you want to be the first to file. So when you're
That's right.
not really necessarily you've not put all of the functionality together in this product. You know what you want to build, but you're not sure. You may want to add bells and whistles, which most inventors do, right? They want to
Yeah.
add bells and whistles to the very simple pen, but you want to add more. So in that 1 year, you could add your bells and your whistles, and then you're ready to file. But are you ready to file everywhere? And one additional question. So now we have filed for that provisional patent. Or can we sell the product? Can we start selling the product with this provisional patent?
Yeah, so I guess you can, yeah, you could start selling the product. So that's the great thing is that's another, I guess, good use of a provisional application. If you're going to start disclosing, you want to file a patent application before there's any public disclosure of your invention. So um, let's say you're going to be kind of meeting with investors or meeting with potential partners or advertising your product. You want to get that something on file before then. In some jurisdictions, you can't even file for patent application if something was you could file it, but you can't get the patent if something is publicly disclosed before then. So yes, you want to get something on file, and then then you could go ahead and uh, you know kind of operate as though you've done what you needed to do to have those to take the steps to get those patent application rights. And then actually,
Mm-hmm.
that's a good point that you say you're still, you file a provisional, you start kind of figuring out, let's say you start marketing your product, then you kind of modify your product, then you actually have a better sense of maybe what am I need to focus in that non-provisional. So
Right.
you have that a year to kind of, um, figure out, hey, maybe it's a very specific kind of out of this broad idea, but it's a very specific way that is going to work. And really, that's what I should
Mm-hmm.
focus in the non-provisional. So it gives you time, but it gives you that protection to take the next steps.
So you've got a sense now. So while you have everybody, you've filed that provisional patent, right? And as soon as you filed that provisional patent, you're not wait. Are we waiting for anything? So you have filed that provisional patent. Are we waiting for anything before we start marketing? Or you say, okay, we're done. I've filed your provisional patent. Run as fast as you can.
Yeah, no, yeah, you could on the business side run as fast as you can, but it's important to remember that you have to, if you want to keep pursuing the patent protection, you have to file another application within 1 year. You don't want to miss
Within a
that one
year.
day deadline, exactly, because you're going to lose your rights. So it's an important thing, and obviously it's if you don't want to, especially if you do it on your own, if you file that provisional application on your own, you want to make
I'm not doing
sure.
that. And I never suggest that ever.
Yeah,
Anybody. Never, never.
yeah,
No, we need you. We need there's no way.
yeah,
It's you know what? You have too much creatively going on
yeah.
to have to worry about, is this right? Check this, check this. Is it proper? No, you're gonna reach out to Eli. You're there's no way. You're not doing this on your own. No way. But no, I mean, so I love this conversation. We can keep it going, and I'd love to keep it going. What's your favorite part about the business you're in as an attorney, as a patent attorney?
Yeah, great question. On a day-to-day basis, one thing that I love doing is actually talking to the examiners at the patent office.
Oh,
So
really? This
after
is
you file,
interesting. I gotta get comfortable. I love this conversation. This is great. Okay.
yeah, so after you file the non-provisional patent application in the U.S., what happens is it's assigned usually to an examiner at the patent office who's focused on the technological area. So they've like been doing it for 20 years. So
Yes.
example I give, there might be an examiner out there, depending on what your technology is, but who's just focused on fishing hooks, or they're just focused on jewelry or whatever it is. That's their specialty. So they've seen, you know, possibly, depending on how experienced they are, but they might have seen thousands and thousands of applications over the years.
Uh-huh.
And in light of that, they see yours and they kind of consider that's you or not. So, and as you can imagine, they have a lot of these that they do, and for them, they're on a production system, so they got to kind of get through them and get through. And then what they do is they get yours and they say, "Hey, is this something new, or is this a combination, an obvious combination of something that's been out there?" And that's a
Mm-hmm.
consideration that's called, they usually do what's called a prior art search. So they look for prior art and seeing, hey, is there maybe other patent applications or other disclosures of this invention that took place before this application was filed? And usually then that what's called, they issue what's called an office action, which lays out why they don't think you should get a patent. And this is where I
That's where
come
everybody
in.
goes berserk. That's where everybody goes crazy.
Yeah, yeah,
I
yeah.
thought I identified this product so it does everything, all the bells and whistles that this pen does. So what is the hindrance typically? Does the pen not have enough bells and whistles? Is the explanation not broad enough to get that patent? Do we need that examiner to say, woohoo, this is something that's so different that we want to give this to you because nobody else has done this before?
Yeah, yeah. I guess it kind of there's a lot of things to do. For example, like it depends on the examiner, right? So uh, fortunately, like one thing I always do is like I try to find out more about an examiner. What are their statistics? How do they usually decide to issue a patent? How do they allow a patent application? So for each one, but yeah, I guess going back to, I guess, the specifics you were saying, yeah. So the each patent application has what it's called claims, and they
Uh-huh.
try to capture your invention as broadly as possible. And usually, what's involved in is um, bringing in more features that kind of define what your invention is, that differently from what else was that out there. So it's kind of like a negotiation. But the issue is that uh, sometimes, the examiner issues their office actions, and then the uh, patent attorney might just, issue a response, and they're kind of talking past each other. What I like to do is
Right.
like get on the phone with the examiner and kind of tell him that story, especially if it's really an independent inventor. Say, hey, kind of tell him that story, tell him why, they took the step of filing that patent application, why, pretty significant step, and why, there was nothing like that, and how they came up with this invention. And hopefully the application already tells that story, but the examiner doesn't have time to kind of, read it and really appreciate it, because,
Exactly.
he has a lot of
And
applications. So
appreciate it.
yeah. So the interview, and also you get to find out like the examiner's perspective. The examiner, it might be a little tweak that they're looking for, and
Yes.
it gives you that kind of, you can find a way to collaborate with the examiner to get those good results, and get that kind of issued quickly, because otherwise, you'll be sending papers back and forth,
Sure.
uh, and it doesn't serve anybody well. So I guess my favorite part is kind of try to find a way to kind of uh, get the examiner on our side, and kind of
You're the best. Do you understand? I've done this for so many years, and I mean, this is what I want. This is the I build relationships. I'm a relationship builder. This is how I keep on going back to QEC and to HSN and bringing clients to where they need to be in order to succeed, right? Your goal, I'm sure, like my goal is to see my clients succeed. They're not succeeding if you send in that application without all of the information necessary to have that client win, because all they're doing is spending unnecessary dollars when you can have that conversation. Like, your favorite thing is, you're my favorite person now, let me tell you something, because this is the problem with clients. Why do we have to go back and examine this trademark? Why do we have to go back and examine this patent? And throwing good money after bad over and over and over again, where you could just tweak the conversation, the narrative in that patent, or in that provisional patent, or in that trademark information. And I love that you are having those conversations. I don't think anybody even knows that you can have a conversation with an examiner. Those inventors out there, I know they don't know this. They do not know. I think they think the examiner is somebody out in Mars, who just, like, there's a Mars person out there who never even sees it. Very much like the whole QVC thing, when people are sending in applications to QVC and just sending them blindly out without having a relationship with somebody.
yeah,
I love that you express this, because you're human. Patent
yeah.
attorneys aren't necessarily humanized, right? Or attorneys. They're just kind of somebody we now email, not even have one-on-ones with.
Yeah.
But I mean, I love this. I love that you said that is your favorite thing. I love it. And what is the response typically when you pick up the phone and you say, I'd like to speak with Richard, or whatever his name is, the examiner who's working on jewelry, or on, you said specific areas, right? So
Yeah.
certain examiners have specific areas. So the
Yes.
jewelry examiner is not the same as I'm sorry to interrupt you. So the jewelry examiner is not the same examiner who's going to be examining, I don't know, water bottles or something.
Exactly. Yeah. Yeah. And it could be even more specific. Like it could be just clasps, jewelry, clasps, or stuff like that. So, yeah, yeah. And usually they're happy. Obviously it's a really big organization, so there's 10,000
Yes.
examiners, and they vary. But usually they're happy to do that, because, especially if they're an experienced examiner, like they know what's out there. They have their kind of vision, and to be able to have the conversation and to find that middle ground, where the examiner is comfortable saying, hey, this is, you deserve this patent, and you're comfortable that it gives you the coverage of your invention in a way that's going to help your business. That's kind of
Hmm.
like a win-win. So it's kind of it's a positive resolution. So most examiners are open to that, and they want to discuss it. And and I think it's kind of important to tell the story. It's a difficult, it's sometimes you describe, sometimes it's the right um, opportunity for even the inventor can go talk to the examiner. So there's an opportunity to do that, but
Yes.
kind of depends on the inventor, on the invention, and the dynamics, and you got to kind of want to figure that out. But that is kind of, um, you know, uh, it's unfortunately one thing that back in the day, you could actually meet the examiners in person. It's much harder to do now. They're more
Yes.
remote, but you can still have video calls with them, and you could do this with the inventor, and
Hmm.
they could see the inventor, and they could kind of like you appreciate the invention in a different level, obviously,
Yes.
if it's an inventor who kind of is there waiting for this patent versus like I don't know, some company that might be getting thousands of patents. So
Right.
yeah.
I would think that the examiner probably feels the same way, right? So if they're not seeing the inventor's passion, how do they really know? I mean, this person has put so much into putting this product together and coming up with their own creative ideas as to why, yes, it looks similar to this, but it's so different because it does this, this, and this. So I would think that there is an appreciation and a breath of fresh air for that examiner to be able to look at that inventor and see their passion, see where they're coming from, and see what they mean by broader and how it could fit into these all of these 5 different categories and not just one.
Yeah, for sure. I mean, another issue is that it's called hindsight bias. So once you see the invention, you're like, oh, that's obvious, because somebody already came up with it. So another thing the inventor could do is, or actually attorney could do, is tell the story about, hey, no, like this is a real problem that they were facing,
Yes.
and this is what it took for them to find the solution. And you know, there was no such solution out there before. So um, kind of you don't want it's kind of be that obviously having the right inventor there being able to kind of give credibility to that helps, and kind of in the right circumstances it makes sense to consider.
Right, the explanation. That's why it's so important for the inventor to be so specific about what that product is, what it means, what the definition is behind that product for you as the patent attorney. Because you're not understanding it unless you can see it, unless you're getting that explanation from the inventor.
Yeah, and you're hitting on another very important point, is that once you file that patent application, you can't be like, oh, I meant to include this or that or whatever. It's too late at that
Too
point. So
late. I
yeah,
know. I know. It happens all the time. But yeah, it's done. You said this is it. This is why
yeah,
you have to be sure. You have to be clear. This is it. Are you sure? Are you sure? I'm sure. I'm completely sure until I'm not sure. But we're never sure. Oh,
yeah,
we
yeah. No, that's right. Yeah,
ever really sure? Not really. Or I should have said that. But that's why you have to not rush, right? Do you agree? Not rush through anything. Take your time and do it right.
absolutely. Yeah. And you gotta look for the patent attorney who can kind of take the time to go on that journey with you in a way that kind of makes sense. The last thing you want to do is spend a reasonable amount of money on that
Yeah.
process, but you want to find a patent attorney who has kind of invested in your success, like you said. I kind of I had recently I had an author, he wrote a book, Jim Edwards. He wrote a book, To Invent is Divine. But part of that book is that uh,
It's true.
he talked about some of these like great inventions that you hear about. Interestingly, I read in his book, he talks about how like what the final form of the invention was.
Mhm.
It came out of their conversation with the patent attorney. The patent attorney was like, well, could you do it this way or that way? And out of that actually came the final form of the invention. So I think it's a good exercise, and when you have a million things going on, it could seem almost a nuisance, a headache. Is like, well, I already hired you. Why? Just go
Right.
do it. But that's an option. But then you're not. Then maybe it doesn't make sense to go through that process if you don't want. If you're not really invested in in obtaining a patent that's valuable.
Right. But people don't understand that. And that's why I love these conversations, because it's so foreign to an inventor, especially a new inventor who's never applied for a patent or a trademark or a provisional patent. It's so foreign, and the journey is always so unique. It's never the same. So it's me having clients, new clients every day, wanting to have a patent, and having someone like you to explain the details and how you may not necessarily need a patent right away. We need to figure out what it is and what it does, and maybe have some engineering experience involved, especially if it's a very, very detailed product. But it's very new, and people do think, or let me just get a patent and I'm free. I'm home free. I have a patent, but you're not. It's just the beginning. And it's where the detail prior to getting that patent, the detail begins, right? We need to be very, very detailed about what that product is, because the patent aspect, you and I both know, is probably the most expensive part besides your manufacturing. You got to keep up a patent. Not only do you apply for a patent, and I encourage people to get patents. I'm not discouraging anybody,
Yeah.
but it's not inexpensive. So have your patent piggy bank ready. Put your patent dollars in there while you're creating that prototype from, by hand or illustrated or whatever. Um, and so appreciate your knowledge, and I love your how invested you are in helping inventors and not having inventors rush to getting a patent. You're explaining, you're building a relationship. And while I'm on this topic, I want to ask you, how important is it to build that relationship with your clients?
Uh, well, yeah, I think it's very important in the sense that you really want to figure out what's their bigger vision, right? Besides getting a patent, right?
Yes.
Because depending on what their bigger vision is, that's how you'll be able to help them, and you'll be able to kind of think, uh, you know, uh, figure out to help them. I just had actually on my YouTube channel, we just recently shared a conversation I had with a patent attorney who helped some dental company obtain patents, right? And it was like
Mhm.
kind of a thing you wear to straighten your teeth. But the main patent that really made the difference for them was the patent about having a sequence of these things, right? So it wasn't really the configuration. It wasn't. So if this company just came in and said, hey, I have this thing and we're going to sell it to people to put in their mouths, you could have filed all kinds of patent applications discovering that
Right.
thing, but it really wouldn't have covered why this business was successful it was successful. And the reason they were successful is they came up with the ideas that you have a sequence of these things, and that makes it
Ah.
easier for the consumers to
Ah.
use. And by the patent attorney, by the patent attorney talking to them and finding out everything about their business, they were able to obtain patents that covered that. And like you said, it is so it's important to have that relationship. Important to know what's going on, and it's important to keep it it's like one in perspective. At the same time,
Mhm.
you don't want a patent attorney who kind of just monopolizes your time.
Yeah.
So you got to keep a perspective and everything else that a
Correct.
business does to make it as easy on them as possible. But you want to know enough to provide that value, broader value.
You want to care enough. You
Yeah.
really you really need to care enough. And I think that's what meant we're lacking. Okay? I mean, I really appreciate you, because you care enough to speak with your clients. You care enough to speak with the examiner and want to, not even nobody's asking you to do that. I mean, a client certainly isn't going to ask. They don't even know you can do it. So, I mean,
Yeah.
I think that relationships are everything in business. I don't care what you're doing. I don't care what it is you're doing in my business. My relationships with my clients are very important. And talk about good relationships, conversations, understanding where that client is coming from. When I get somebody on the phone for the first time, I say, slow down and tell me who you are. What's your background? What do you love to do? What do you do in your spare time? Like, what is it? What makes you the inventor that you are? Because I'm sure, much like you, clients may come to you after they've just watched Shark Tank. I think I brought that up on your show. I
Yes.
just watched Shark Tank. I came up with an invention and I need it patented today. How much and when is it going to be patented? When is it going to be finished? When am I getting my patent? So having that explanation and that conversation and building that relationship with that client so they understand that you need to understand where they're coming from in order to help them is very important.
That's right. Yep.
So I love this. I love our conversation. I mean, we definitely have to do this again. Uh, is there anything or last words that you want to shout out to inventors or people who want to invent or have intellectual or patents? And what do you have to say about it, Eli?
Sure enough, thanks. I'm very lucky to be with the inventress on your show. So thank you for inviting me. I guess the only thing I guess I want to mention is we start talking about how obtaining a patent is not a guarantee of business success, but it's important to also have a healthy perspective in terms of obtaining a patent is not a guarantee of securing your business success. So it's not. I know you've had a
Ah,
lot of success with, and we talked about it with, if you do have a patent, most of the time people will respect your patent rights, but sometimes they don't. And actually, on my show on Clause 8, I've talked to the inventor of the bunch of balloons, which is the most popular toy in
yes.
America. I talked to the inventor Dan Brown, Professor Dan Brown, and his son who invented the bionic wrench. I've talked to Molly Metz. She invented the jump rope. And the reason I talked to them is unfortunately they didn't have, um, I guess, fully positive experiences with the pound system. And I think it's an important perspective to have. Um, one is because I'm sure who's everybody watching it, they appreciate innovation, they appreciate inventors, and they know we need to create a system that our founders thought of when they wrote the Constitution, where that's
Yes.
rewarded. Um, but also, kind of to think about that just getting one patent, if that's all you have, if you have the piggyback for patents and you're just going to get that one patent, that's probably not. That might not give you like a end all be all protection for what you need for your business.
Hmm.
So that's just something to have, just a healthy appreciation for what a patent actually provides, the limits of it does, and to kind of walk into the process with an open mind. Sorry, to walk in the process with kind of knowing what you're getting into yourself into, and knowing the role that it could play to help your business, but the limitations of that as well.
This is so amazing to me. It's so appreciate and love have you on my show. How can people get in touch with you?
So I think the best way they could email me, Eli at voiceofip.com. And I encourage everybody to, I guess, they could subscribe on www.voiceofip.com. I have an email newsletter that shares the latest episodes, and on YouTube, the Clause 8 podcast channel, we share some of the content that we put out for our podcast. So they can reach me there. But yeah, feel free to email me. I'm always love hearing people's stories. So reach out, and glad to talk to you, and glad to find out how I can help, and hopefully at least point you in the right direction.
You're amazing. You're amazing. And you're on all social media platforms?
I'm on LinkedIn. I'm on we have a Closet Instagram channel, and a Twitter. So yes, if you follow us there, and reach out as well.
So no one will forget this. No one will forget all of the actions you've provided. Your clause 8, your article 1 section clause article 1 section 8. Article 1 section 8. No one will forget this. I love it. Now I'm going to go back and read the Constitution. go back. Like I read the Constitution on a regular basis. You're amazing. You're amazing, amazing. Promise me you'll come back on my show. Love
I
to
will.
have
I
you
had a
again.
lot of fun anytime. This was love getting to know you, and I look forward to
I
meeting
appreciate
again.
it.
So this was great.
Definitely. And in person. Wait a second. Hold on.
Yeah,
We're from the same place, except I was born in London, raised in Brooklyn. You're from Brooklyn,
that's right.
right?
I was actually born in the Soviet Union, but I lived in Brooklyn. But my family lives in New Jersey, so yeah, we'll have to together over some New Jersey pizza one of these days
We
for sure.
100%, 100% Jersey pizza. We'll figure out where that is.
Yeah,
So UK born me, raised in Brooklyn. We have so much in common. We definitely have to have pizza. No two ways about it.
yeah,
All right.
for
You
sure.
take care. I can't wait to see you again in person. In person.
Yep,
Thank you.
we'll do that.
Okay. Take
Thank you.
care. Bye.